Welcome to another episode of the Criminal Law Department Presents podcast, a production of the Criminal Law Department at the Judge Advocate General's Legal Center and School in Charlottesville, Virginia. Every 2 weeks, we release a new episode. Today, we're going to have a conversation about a recent opinion from the Court of Appeals for the Armed Forces. Please note that these episodes may contain facts and circumstances surrounding criminal trials. Listener discretion is advised.
All rise. Hear ye, hear ye, hear ye. The Honorable United States Court of Appeals of the Armed Forces is now open and in session. God save the United States of America and this honorable.
Hello and welcome to another episode of Criminal Law Presents CAAF Chats. Today we're going to earn our namesake as we have a special episode for the listeners out there. I'm joined, as most of the time, by Major James Barrett.
Hello, everybody.
And our special guest today is the Honorable Liam Hardy. Sir, thank you so much for joining us.
Good afternoon. It's my pleasure to be here.
We join you actually from the CAAF chambers. We were in the judges' conference rooms. It's kind of a surreal experience, James, wouldn't you say?
It is very surreal. I wish the listeners could see the smile on my face. This is truly awesome.
Okay, sir. So let's get into it. So our first question for you: How did your career path lead you to the bench? So I'm asking for James here, sir. How does someone become a CAAF judge?
Well, I don't know how much my experience will be of use to you, but I can, because my path is a little different from all my colleagues. I am the only member of the bench currently who is not a veteran. So two of our judges are retired active duty. We have one judge who's retired from the reserves, and then we have another judge who is a veteran. And so I am the only pure civilian to sit on this civilian court, so to speak. I was an aeronautical engineer in the Army Materiel Command earlier in my career, but I know that does not count. But I am incredibly honored to be able to serve on CAAF.
Thank you, sir. On this podcast, we generally talk about the briefs and the results of the cases that are argued in front of your court. What is the process, briefly, of how something gets in front of your court?
So we are very fortunate to have a central legal staff who is headed by David Anderson, our chief deputy clerk, who is himself a retired Marine JAG. And they do the initial pass. They receive the petitions and the supplements, and they review them. They make a recommendation that Mr. Anderson then comments on, he reviews and comments on, and then that goes to each chambers individually. And each chambers handles that recommendation in their own way. I can tell you in my chambers, they come straight to me. I review all the petitions and supplements myself. Mostly because I want to see the entire range of cases that are coming up to CAAF, both those that we're granting and those that we're not. I read them. Sometimes if I find something of particular interest and I want a second opinion, I will bounce it down to my own law clerks to get their thoughts and opinions. But then at the end of the day, I make it my own vote. And all the judges vote individually. That we have a central computer system that keeps all the votes, and then generally speaking, the vast majority of the time, it's unanimous. On the occasions when it's not unanimous, we most often will then get together in conference to talk about the petition. There is usually some curiosity among the judges about why one judge thought this was a case worth hearing, while other judges perhaps didn't. Sometimes there are lurking issues that make a case not a good vehicle to address a certain issue on the merits. There may be forfeiture issues or waiver issues. There may be other reasons why the interesting legal question that the case presents may not really be we may not be able to get to the issue. And so generally speaking, once we've talked about it, we'll vote again. And on rare occasions, there is just one judge who wants to hear a case. Because generally, after we talk about it, we come to a unanimous agreement. But on those occasions when we don't, it only takes two judges to hear a case. And very rarely, we have one judge who's very interested in a case in particular, and we have a very cordial court. It's been that way since I've been here. And what usually happens is one judge will give that judge a courtesy vote, because if there's one judge who really wants to hear a case, then we believe that it's probably worth hearing, even though it generally takes 2 votes.
And I know the court rules specify some things you're looking for when granting a petition. Could you talk about those a little bit?
Yeah, so our Rule 21 points out we grant petitions for good cause, and good cause is described in Rule 21. And some of the things that establish good cause are a novel legal issue that the court should address. If there's any disagreement between the service courts or between the service courts and Supreme Court precedent, that's good cause to grant a case. Sometimes if the service courts have adopted a procedural or evidentiary rule that is contrary to the rules as they apply in civilian courts, that can create good cause. And these are all the sorts of things that we are generally looking for. I also have a sort of a shorthand way of thinking about this is we are looking for cases that will provide benefit to the field. We want to take a case that will either clarify the law or correct a misunderstanding, or at least something we see as a misunderstanding. Sometimes that misunderstanding is our own fault from something that came out in one of our opinions that we didn't mean to say, but that's how it's been interpreted. So generally speaking, the shorthand, the way I think about it, is what benefit would it do to the military justice system's jurisprudence for us to hear the case and write an opinion about it. I think one thing that I think many people maybe don't particularly understand is we try not to do error correction. So we don't see our role as offering just a second bite at the apple on an issue about which reasonable minds could disagree. When the CCA has correctly stated the law, correctly applied the law, and it just comes down to a difference of judgment, could reasonable minds agreeing on what the law is come to different conclusions, we don't generally view it as our purpose to just give a second bite at the apple. Will these 5 people decide this issue if everyone agrees on what the law is in a different way than the 3 judges below did? Of course, that's not always true when the Chief Judge Advocate certifies a case to us. But when we're working on our discretionary docket, we try not to do what we refer to as error correction.
It's funny you went there, sir, because I was automatically thinking, I was like, well, what about when TJAG says, well, take a look at this again, Kat. Speaking about that unique perspective that you have, so the court oversees everything from all of the services. So from that perch, what trends in military justice are you seeing at the highest level, and what do you think practitioners could be doing better given those trends?
I think one of the common things that we see, and this is something that's really an issue for trial counsel, is going right up to the line of what's permissible, whether it's argument or whether it's pushing questionable evidentiary issues or going right up to the line on deadlines. You know, at least from my perspective, the government generally has all the cards in their favor. They have control of the charge sheet, and generally speaking, they get to decide what to charge and how to charge it. You know, given that, at least from our perspective, it shouldn't really be necessary to go right up to the line of what's permissible under the law in order to prove their case. But we get instances where trial counsel in particular are going up to or even crossing that line in cases where, at least, you know, on a cold record, it doesn't seem like that was probably necessary. And that's something that we see repeatedly.
Yeah, and I think we've talked about that a few times, especially in the improper argument cases. And I know James and I have talked about this in particular, like why go too far when all the things are in your favor anyway?
So one of the things in my previous job as a senior defense counsel, a lot of people thought that just object, and you create an appellate record, and then maybe you'll win. Because everybody's afraid of either waiver or forfeiture, which, again, are sometimes often misunderstood words and terms. What advice do you have for practitioners to stop the objecting, and to build a actual, legitimate, helpful appellate record?
So you know, I think this is a real issue, and it is difficult. But the things that I would suggest, and when we have many cases that get decided, as you have noted in the podcast many times, on sort of a failure to establish a record. And so, you know, my advice would be, you know, sometimes I think first I would say ask for a 5-minute recess. I think often, you know, it's easy to say from our view at CAAF, where we have the luxury of time and a lot of, you know, we can look at this. from an appellate view, and we can take all the time we want. And I know at the trial level, you've got 1,000 things going on, and and things are going 100 miles an hour. And I would say, at first, I would say, just if you think there's an issue or there might be an issue, but you want to double check, you're not sure. First thing I say, ask for a 5-minute recess. Check with your co-counsel. Go back to the manual. It doesn't hurt to double check. The worst thing that's going to happen is the judge is going to say no. And then, after that, I would say, I think sometimes counsel are afraid that they're not using the right words. They're not citing the rule, or they can't remember the rule number, and they know they know something's not right. And they're afraid, I think, or worried that if they make an objection and they can't cite the rule or they can't use the perfect language, that it will be embarrassing, or it will be the objection will fail. And there are some judges who are more stringent about this than others, but I would say at least get your concern on the record. Even if you don't know the rule, if you feel like something is wrong, or there is an issue or a conflict or a tension, at least get it out. And you can't cite the rule, you can't think of the magic words. At least get it on the record, because as you've mentioned, forfeiture and waiver are real problems. And if you can at least get the concern out, you can establish a record that you were thinking about this, it was presented at the trial level, and hopefully it gives you a better chance, if there was an error, to preserve that error going forward.
So as you're well aware, Your Honor, the practice of military justice is always evolving, and that evolution really has seemed to increase in speed and intensity in the most recent years. So how do you recommend that practitioners stay on top of all the changes that have been occurring recently?
Well, to be quite honest, the best resource I'm aware of right now is this podcast. And I'm not just saying that to be kind. I mean, it really is a wonderful resource, I think, for the fleet and field to stay abreast of at least the opinions that are coming out of CAAF. What are we thinking about? I'm embarrassed to admit that I only became aware of the podcast a few months back, but I'm up to speed. I'm caught up. I'm a fan. And I'm so impressed with the way that you digest our opinions and present them to the JAG Corps in a very understandable, digestible manner, so that someone can, while they're going to work or going for a run or doing everything, in 20 minutes, you can get an understanding of what's going on at this level. You're right. It is very hard to keep up with all the changes to the UCMJ and to the manual. At the end of the day, you can find summaries. I have to imagine the services put out summaries of this is what's new in the new manual, this is what's changed in the UCMJ. Those are valuable. But at the end of the day, I think if I was a practitioner getting ready for trial, I would go back and reread the rule, because I think a lot of time there's a lot of conventional wisdom about the rule says. As you've pointed out on the podcast several times, we live in a textualist world now, and this is a textualist court. And that's what we're going to do. We're going to go back and read the rule, and it may be our view of what that text says may be a little inconsistent with what this court said that text said 15 or 20 years ago, or what the conventional wisdom has interpreted that text to mean. And so my advice to a practitioner, if you're getting ready to file a motion to enforce a rule, whether it's an evidentiary rule or a procedural rule, just go back and read it again and make sure that what you're going to argue is consistent with the plain language.
I think you just made James' heart explode, sir, by saying read the rule. That's his slogan with all of our students. Just read the rule.
All I do is make the OBC and grad course affirm that they know how to read and go back to the rule. And it kind of goes back to developing that foundational knowledge. And so if you're a new practitioner out there, and I look at the CAAF Digest, there's literally hundreds of cases. If you could put your finger on 3 of those cases to really start to build that Rolodex of knowledge, what would you suggest an early practitioner do?
So, as you said, if I was getting ready to litigate something, the first place I would go would be to CAAF's Digest. That our central legal staff puts that together. I'm glad to hear that the people are aware of it out there, because it's a wonderful tool for us here in the courthouse. I hope it's a wonderful tool also for the field. But if you want to talk about specific cases, one of the cases that I think everyone should go out and read, especially given how many courts martial end in guilty pleas, is United States versus CARE, which is all the way back from 1969. In that case, the court sort of established what is necessary for a guilty plea to be voluntary. And it's not based on any particular provision of the UCMJ or of the manual, or the case in 1969 it wasn't, but it was based on the court's view at that time of what is necessary. Many people have recognized that the military justice system is an inherently coercive environment, and so the military justice system has long taken extra care, far more care than they take in the civilian world, to ensure that guilty pleas are provident and voluntary. And I think going back to the source of care is always something that's valuable to do. A couple of other cases that I think are sort of maybe valuable teaching lessons. One is United States versus Stellato, which was a case from CAAF in 2015. And that case really emphasized trial counsel's duty to take care of their discovery obligations. And in that case, the trial counsel were somewhat reckless, and the court even described their behavior as egregious, with failing to satisfy their discovery obligations, and it resulted in the case being dismissed with prejudice. So it really can, if you are a trial counsel, you can blow up your whole case if you are not diligent about providing the defense with everything that they are entitled to. Another case that I picked as sort of an example of, again, this is for trial counsel, they have a tremendous flexibility in deciding, as I mentioned earlier, what to charge and how to charge it. But trial counsel need to understand that once they've made that decision and once the charge sheet is finalized, the courts will hold them to that, to what they've chosen. And so in United States versus Mader in 2021, this court reversed a conviction because it was charged. It was essentially a hazing incident that was charged as simple assault. It wasn't charged as hazing. And the difference between simple assault and hazing, or more egregious type of assault, is that for simple assault, consent is a defense. And the courts had stripped the accused of his ability to raise a consent defense. And we said no. Once the government elected to charge Mader, the accused, with simple assault, then they were bound by that decision. And even though it looked like hazing and it felt like hazing, hazing's not what they charged.
Contrasting to like an Article 93 violation for maltreatment, where consent is not a defense.
And to build off that, Your Honor, so those are the three cases every new practitioner should read. What about the ones that you think have been instrumental on the practice of military justice itself? So what three cases would you point to as shaping our practice most today?
Right. So from a big picture standpoint, I think the first and the most important, and I'm not suggesting that anyone go back and reread this whole case, is Ex parte Milligan from 1866. And the reason I say that is because in that case, the Supreme Court stripped service members of their Sixth Amendment jury right. And they did it in a remarkably casual fashion, in my opinion. And I think you could have a really interesting debate over whether that opinion was rightly decided. In my view, and I think the court's view, as we stated in Anderson, they have never backed away from that initial determination. And I think it's a big deal. If you look at all of the landmark Supreme Court military justice cases, especially from the 50s and 60s and 70s, there are three things which, in the Supreme Court's view, differentiate the military justice system from the civilian system. One is no Fifth Amendment right. That makes sense. It's right in the amendment. One is no Sixth Amendment jury right. That comes from Ex parte Milligan. And then the other is you never get before an Article III independent judge. And if those are the three linchpins of what makes military justice different from civilian justice, I think that's remarkable. Second case I would mention would be United States versus Solario in 1987. After a brief 18-year experiment with a service connection test, and this is for basically service matter jurisdiction, if you're a service member, what can you be tried for at court-martial? For 200 years, the answer was anything under the code. And then in the 1960s, the Supreme Court decided, well, maybe we ought to have a service-connected test. And in the Supreme Court's view, that was a failed experiment, I think it's fair to say. And then in Solario, they backed away from that. And just now the only test for whether or not you can be tried at court-martial is status of the accused. Are you a member of the land and naval forces? And so I think that was a remarkable, it settled the question, at least for now, of what is the subject matter jurisdiction of court-martial. And then the last case I would mention is Parker v. Levy from 1974. Yeah, 74. And in that case is a landmark case for any number of reasons, First Amendment reasons. But from a military justice perspective, I think what you can really take away from it is it firmly established the principle that in the military justice system, your rights, including your constitutional rights and your due process rights, can work differently. And because of military necessity, your rights will be different in the military. And that's, service members, when they put the uniform on, they sacrifice many things. But one of the things they sacrifice, and they may not be thinking about when they do it, is some of their due process rights. And Parker v. Levy really firmly established, it's never really been questioned since, that's permissible under the Constitution.
Thank you, Your Honor. As you're probably well aware, court-martials are stressful, and there's a lot going on for everybody. And we see some recurring issues out there of either improper argument, IAC, UCI is always around, and then judicial disqualification, Your Honor. What is it about the military justice system that causes these concerns to rise again and again? And then, as a side, what can we do to avoid them?
So what I think is probably one of the primary root causes of these issues is the sort of inherently hierarchical and coercive nature of the military environment. And so there is always a question of the various actors, whether it's the council or the panel members or the military judge, are they solely focused on the legal issues in front of them, or in the back of their mind, do they have secondary concerns about promotions, about their future in the military? These are not concerns that exist in the civilian world. No one's ever going to get angry at a jury member. No one at their work is going to get angry for them for how they voted in a criminal case. And so the military justice system recognizes this and has tried to prevent it. You can't change the nature of the military, but they do try to take precautions to try and address these issues to the best they can. I don't think it's for trial counsel and defense counsel, they have the duty to be zealous advocates for their clients. So I don't really think the burden is on them so much. But the only way I've ever really thought about that one could sort of help address these issues is when it comes to commanders and staff judge advocates. I think by default, there's an inherent tension in the military justice system between the need for good order and discipline and the due process rights of the service members. And that tension will always be there. It's always been there. It will always be there. And the trial counsel are working on behalf of the government, and the defense counsel are working on behalf of the accused. But there are other actors involved, and including the commanders and the staff judge advocates. And one thing I've said before is that commanders maybe need to think about both sides of the equation. They don't just have on a good order and discipline hat. They also have a duty to look out for their service members under their command, and and then with the counsel of their staff judge advocates, give some thought to what is the right answer here, not maybe just in terms of good order and discipline and military readiness, but also what is the right answer for this service member.
Maybe kind of going back to asking that judge for 5 extra minutes to think, maybe asking that commander or that subordinate or superior that extra 5 minutes to think.
I want to go back to something that we talked about just a few minutes ago, Your Honor. So James asked you about building an appellate record. I will tell you, as practitioners, especially 2 practitioners that have worked on the appellate level before, we're always concerned about whether something is waived or forfeited because different rules apply very differently. The CCAs seem to go back and forth on whether an issue is waived or whether an issue is forfeited. How can we at its core understand this when there seems to be so much confusion about these 2 standards?
Right. And so, waiver is, primarily waiver is the intentional relinquishment of a right, whereas forfeiture is simply the failure to assert a right. And that makes sense, and I think everyone understands that. I think where the primary sources of the confusion comes from is forfeiture by operation of law. And so it certainly makes sense that sometimes forfeiture can be converted into waiver because just for practical reasons, that's the only way that makes sense. For example, if you fail to object to the admission of a confession or an admission by the accused, once the panel has heard it, they can never unhear it. So that's one of the areas where once you fail to object and once the confession has been entered into evidence, Generally, then any objections at that point would be waived. Otherwise, the system just practically couldn't work. So waiver by operation of law makes practical sense. I think part of the problem is this court and the other appellate courts have not always been diligent about the difference between waiver and forfeiture. We have opinions in our jurisprudence where we have sloppy language. I think the president in the manual has not always been diligent about maintaining the distinction between waiver and forfeiture. And so there's something I know that the judges on this court are trying to be much better about and trying to clean up when we can in our own jurisprudence. I know there have been changes to the manual to try and also clean up some of this confusion. But I think at the end of the day, in my view at least, the court needs to stick to a narrower view of waiver. Waiver really needs to be an intentional relinquishment, whereas forfeiture needs to be, otherwise it just results to forfeiture. And, when there is an operation of law, that operation of law needs to be very clear, and that it doesn't make sense to assume when the law is ambiguous that something that, we should default to forfeiture instead of waiver.
Yeah, because the language in waiver is pretty strict and stringent. There is no error to correct, and I know that's always been a big fear. When I was been a defense counsel, I was like, I need to not waive this.
In other words, no objection when I was at the Defense Appellate Division was devastating. A little longer question for you, Your Honor, but I want to ask you about Article 66 and how some of the CCA's powers have been curtailed. In United States versus Anderson, the CAAF noted that Article 66 provides a safeguard for service members that are convicted by a non-unanimous verdict. Do you think the erosion of Article 66 and the accompanying CCA review powers has weakened this argument? Also, do you think that appellate IAC will become more commonplace given that the requirement that an appellant must raise an issue before the CCA can address it?
So I think as the court stated in Anderson, this change didn't really affect our analysis. And our analysis came down to the Fifth Amendment argument and also the equal protection argument. And at least speaking for myself, the reason I feel comfortable with that position is I don't think those were close questions. And so I agree with you. There has been an erosion of the Article 66 review, but not an erosion that's so significant that it would bring into question the court's ruling on the Fifth Amendment issue and the equal protection issue. It remains to be seen exactly how the amendments to Article 66 will play out. We have only gotten, I think, one case so far that has really presented this issue to the court. So it's a little speculative just to say exactly what the difference will be. But I don't think, and I don't believe my colleagues believed, that the change would be so significant as to call into question our reasoning about why unanimous verdicts are still constitutional. I think the primary path for the military to adopt non-unanimous or for unanimous verdicts would be either for the Supreme Court to revisit Ex parte Milligan and change its view about the Sixth Amendment and the military, or for Congress to simply to change the law, which they are more than capable of doing anytime they choose.
So we've talked a lot about changes, and that's been a kind of persistent theme over the last 5 years. So do you think that all the changes that have happened in military justice have made it difficult for junior practitioners to practice in this area?
So I will speak from my own experience. The changes have made our jobs here at the court more difficult. And as an example of that, there used to be confusion in a given case about which version of a rule or which version of the code the parties were all speaking about. And to resolve that confusion, we changed our own rules to require the parties to explicitly state in their briefs which version of the code or of the rules they were referring to, and that way at least we would all know whether or not we were all on the same page. So knowing that here, where we have the luxury of time, again, as I've said before, knowing that it's made our jobs more difficult, I can only imagine it's made service members' jobs even more difficult. There's a 2 to 3 to 4 year lag between when these offenses happen and when they get to us on appeal. And so we haven't even seen yet the most recent changes, but we know that that's coming, and I have to imagine that it's very difficult to keep all the changes in the rules straight.
But you heard Judge Hardy. You listened to the podcast, and we'll keep you as straight as we can. Sir, before we let you go, I have a couple of softballs for you. So you talked earlier about your career path a little bit, where you were an aeronautical engineer. So how does that lead to a job on CAAF? Like, what interests you about this job? So why a CAAF judge after that path?
Right. So so if you go way back in my history, when I was 16 years old, what I would have told you I'd be doing was I was going to go to the Air Force Academy and fly F-15s. I am a little bit colorblind. That didn't work out for me. But I have maintained a sort of a military adjacent career. And as part of that, I was an intern in the DoD General Counsel's office when I was in law school. I had the privilege of clerking here at CAAF for Judge Ryan immediately after law school. And Judge Ryan instilled in us a deep respect for the purpose and the role of the appellate courts in the military justice system. If you're a fan of history and you know the history of the military justice system, you know that it has not always been as defendant-friendly as it is today. Some people would argue that it's not defendant-friendly enough still, but it has certainly come a long way since the pre-World War II days and even in the World War II era. And we've mentioned already today that there is this inherent tension in the military justice between good order and discipline and the needs of the military and the due process rights of the service members. Military justice wants to be fast and efficient and definitive. And due process rights usually require the exact opposite of those three things. Additional layers of review, more time, more opportunities to defend yourself. And so, I see the role of this court as being to maintain the proper balance between the needs of the military, the very valid and real needs of the military for good order and discipline and military readiness, and the constitutional and due process rights of our service members. And it's a job I take and my colleagues take very seriously. I think it's incredibly important, and that's what we try to do, is try and maintain the proper balance.
So, Your Honor, just thank you so much for taking the time to speak with us and being a fan of the podcast. We want to thank you and your staff for making everything possible. We'd also like to thank Colonel Trevor Barner, our department chair, for trusting us to do this, and the schoolhouse support that we get from Colonel Kennedy, the dean, and General Erisman. And then a special thank you to General Allison Martin for helping put us all in contact together. The smile has not gone away, sir, and hopefully in the future we get to speak with you again.
I would like that.
As always, thank you again to all our listeners. Hopefully you enjoyed this episode. As always, please subscribe and rate us 5 stars. Until next time.
Thanks for joining us today for another episode of the Criminal Law Department Presents podcast. If anything you heard sparked a thought, we'd love to connect with you. Your comments help us create better future content for the field or the fleet. Reach out to us on Facebook or Instagram. The information can be found in the show notes for today's episode. The views expressed in today's podcast are those of the presenters and not necessarily the Judge Advocate General's or the Department of the Army or the Department of Defense.
Thanks, counsel, for both sides. And the court will stand in recess until further order of the court.